Continuing Avery pretrial, State of Wisconsin, Circuit Court, Manitowoc County, Branch 1. State of Wisconsin, Plaintiff versus Stephen Avery, Defendant. Motion hearing, case number 05-CF381, date December 20, 2006. Before the Honorable Patrick Willis, Circuit Court Judge. Appearances, Ken Kratz, Tom Fallon, Norm Gahn, all special prosecutors on behalf of the state of Wisconsin. Dean Strang, Jerome Buting, attorneys at law. On behalf of the defendant, Stephen Avery, defendant appears in person. The court at this time calls the state of Wisconsin versus Stephen Avery, case number 05-CF381. This matter is scheduled for a status conference today, and I will indicate for the record that I met with counsel before we began today, and they informed me of the status conference. There are a few matters to take up for the record. Will the parties state their appearances for the record, please? Attorney Kratz, Your Honor, the state appears by Calumet County District Attorney Ken Kratz, appearing as special prosecutor. Also, prosecutors Norm Gahn and Tom Fallon. Attorney Buting, good morning, Your Honor. Buting and Williams by attorney Jerome Buting, appearing on behalf of Mr. Avery. Also, Dean Strang appearing on behalf of Mr. Avery. Mr. Avery is present in court. The court, very well. Mr. Buting, I believe you indicated you wish to take up a matter concerning a motion recently filed by the defense. Attorney Buting, yes, Judge. The defense filed on December 6th a motion to allow the court to grant us access to a particular exhibit that we discovered has been sitting in the clerk's office in Manitowoc County in Mr. Avery's 1985 wrongful conviction case. We discovered that a vial of his blood, or what we believed was a vial of his blood, was in a box in that vial, and we filed a motion. We would see that box itself, the seal, the evidence tape seal, had been broken and that had been resealed with a piece of Scotch tape. We did not want to open that to see if there really was a vial of blood in that box until the court allowed us to. So we filed this motion. The court initially sealed it. I understand the court is unsealing it today. The court grants the defense request. The parties, including the prosecution team, went to the clerk's office last week. The box was opened, and there was, inside of it, a styrofoam box that had also at one point been sealed with evidence tape. The evidence tape had been cut open, and inside the styrofoam package was a liquid of Mr. Avery's blood in a tube that was also unsealed and therefore available to anyone who wanted to use it to plant evidence against Mr. Avery in this case. We filed our motion and set forth some of the links that we believe established at trial. At issue is it remain now are whether or not any sort of forensic test can be done on the blood that will shed any further information for either party. That is something that the state and I will be working on in the next week. The court, all right. Mr. Gunn, are you handling this one for the state? Attorney Gunn, yes, I am, Your Honor. The court, with respect to the defense motion, specifically, what's going to be done with this blood? What's the state's position? Attorney Gunn, Your Honor, the state's position is that we would like to have access to that vial of blood. Our initial investigation in looking into this matter has revealed that although we cannot determine who was the source of drawing this blood, and there may be some questions on the chain of custody. At this point, we just haven't had time to fully investigate this matter. In any event, we would like to have access to the blood. There's some chemical testing that we would like to do with this blood. We're confident that in testing that we anticipate doing is going to show that this blood had absolutely nothing to do with the case that is in front of the court. And we also are in the process of interviewing individuals who did have contact with that blood, but that was under the court's approval back in Manitowoc County, and the individuals who did unseal the blood. It was done under the auspices of the court, and there was nothing really surreptitious or some type of lapse of security, or this could have been planted, and we're confident we'll be able to show that. But in order to do that, we would ask the court to unseal the blood, give us access to it, so that we can this for testing. We're so confident in our position that we're more than willing to split the sample if the court wishes with the defense. In any event, we certainly would like to get on with the testing, and we believe that will show this vial of blood had absolutely nothing to do with the case before us. The court, all right. With respect to how long this matter is to be handled, Mr. Buting has the defense determined yet whether or not it wishes to test the blood. Attorney Buting, Judge, it's my understanding, and I don't believe that there are any tests that can be done on this vial of blood that are really going to shed any more light on either side. I may be wrong. Mr. Gaunt may find someone who thinks that something else can be done, but I very much object to unsealing this evidence and allowing the state to have free access to this blood at this time. What we discussed in chambers, I think, is a fair way to deal with this, which is that Mr. Gaunt and I will talk between now and the end of the year, December 31st, to see if there is a joint proposal we can present to the court. But my feeling at this time, that is, if there is any transfer of that evidence, I want notice to the defense. I want potentially a representative from the defense present during change of custody, if not even perhaps during the testing itself. But I think we can work that out between the two of us. And if we can't, then we can bring it back to the court for decision on how it should be handled. At this time, though, I do strongly urge the court to keep this evidence locked in the safe at the clerk's office in Manitowoc County. The court, all right, Mr. Gahn. Attorney Gahn, may I address that, Your Honor? The court, go ahead. Attorney Gahn, what I would ask the court to do this is, again, we're confident in our position with this vial of blood. I would ask the court to, what would be the mechanism? Assume that firstly, well, wherever we find a place to send this blood, I will call Mr. Buting. They would be welcome to accompany our people, or whoever is doing the testing. They would be welcome to hire an expert to watch the testing. They could even send someone along to accompany the vial of blood wherever it goes. We'll make that opportunity available to them. My concern is this: we're coming up quickly on the trial date, and there are some places that I believe we may be able to send this vial of blood. Assume that this Friday I come up with a place that I believe is going to give us accomplish the testing that we believe would be appropriate in this case. I will notify Mr. Buting that will be, and he will be welcome to send his expert or his people along. And the main thing I'm concerned is, if I want to send one of our investigators to Manitowoc County to get that blood, we'll be able to have access to it. That's why I'm asking that it be unsealed, and Manitowoc County officials know that. Should a representative from the state, and it may be either a Calumet County sheriff or someone from DCI, to come pick it up, that blood, and they can take that blood from the safe. Attorney Buting, and that's exactly what I don't want to happen. If something happens this Friday, then Mr. Gahn can contact me. If we reach an agreement, we can certainly notify the court by stipulation. We could fax, email motions back and forth, and the court could certainly sign an order promptly. I don't see that there's any need at any time to give carte blanche access to this. I have had this experience in other counties, that the only way that I know that you can ensure that the defense is notified. Sometimes the clerk doesn't realize that's part of the requirement, and they go ahead and release it to the state without telling us. The only way to do it is to, in a secured place now, sealed in a safe, with we hope, very limited access. And it should remain that way unless the state can find somebody, if they wish, who is going to do some of the tests. And with regard to the closeness of trial, this has been sitting in the clerk's office throughout the time of the prosecution. This is not some hidden evidence that the defense is dumping on the state, or at the last time. They had every bit of the same opportunity we did to go search the record, particularly since Mr. Avery and his family from the very beginning have been claiming that this blood was planted against him by someone in this case. And now we have discovered that blood did exist where it could have happened. It was unsealed. The seals have been broken. and I think that the parties can work this out. If Mr. Gahn is concerned about the delay, part of that is because they just chose not to investigate the case and Mr. Avery's claims thoroughly like they should have. The court, all right, I will I will make the following observations. And I hear the parties. I don't understand really. There is a dispute between the two parties as to the mechanism for testing of the blood. The defense doesn't feel it necessary for the blood to be tested. The state indicates it does and is willing to allow the defense to participate in really without restriction in overseeing and the testing of the blood. Now, the defense is indicating if the blood is tested, that's what it wants. So I'm anticipating that the parties are going to reach an agreement here. I will give you until December 31st is a Sunday, yes, Sunday. So I'll give you until Tuesday the 2nd to agree. If the parties don't agree, the state can file a motion to examine the blood on such and such terms it deems appropriate, and the court will take up that motion and set it for a hearing in a very short order if it's determined necessary. But I have to say, based on what I hear the parties are telling me on the record today, I'm not sure why that should be necessary. Attorney Gahn, Your Honor. The court, yes. Attorney Gahn, may we also have relief from your January 19th date where you set forth at the turnover the list of rebuttal witnesses. Since I don't know if we'll be able to make that date, I would like to have relief from that also. And the other final question I have is, assume on Friday there is a place we want to send this blood. Is it with the mechanism of getting that blood into one of our sheriff's or DCI agents' custody to get it into the mail, simple as we'll call Mr. Beauty, and we try to do a conference call Friday? And would it be simple as to making a phone call to Manitowoc County saying so and so is going to come down on this date, say next Tuesday, you may release it to him? Is it that simple? The court, well, you can fax me a stipulation, and certainly based on the stipulation, I could order that it be released under the terms of your stipulation. If you don't reach a stipulation, then it gets a little more complicated. With respect to the rebuttal witnesses, before I would allow a party to have relief from the deadline that's been set, I would like to make an alternative arrangements for when the rebuttal witnesses would be notified. I will say on the record that based on the late notice to the state of the development of this evidence, this certainly sounds like grounds for relief from the existing deadline. But as far as acting on this motion that you just made on the record, I would take that up at such time that it's coupled with a description of when the notice would be provided. Is there anything else that either party wishes to take up on the record at this time? It is my understanding that the state, specifically Mr. Kratz, was looking for some clarification of discovery items. Attorney Kratz, I am, Judge. In chambers, we discussed the lack of materials being provided to the state on February 1st. The state filed a reciprocal discovery demand with the defense. It was our hope that by 15th of December, the date that the judge had ordered for the exchange of discovery, that we would have received the witness statements or reports from investigators that summarize the statements from witnesses. We understand that expert reports may accompany an expert witness list sometime in early January, but the lay materials we had hoped would have been provided by the 15th, and if they're forthcoming, we would appreciate notice of that fact. The court, Mr. String. Attorney String, the state had every right to expect that by December 15th. Indeed, the court's order set that as a general discovery deadline. I dropped the ball or let it pass, being focused on the witness list at the time. We have a limited amount of material that I think does fall within the discovery statute. We discussed this in chambers, and I will make every effort to get that to Mr. Kratz, if not this week, then certainly between Christmas and New Year's. The court, Mr. Kratz, anything else? Attorney Kratz, no, Judge. If I can get it by the first of the year, that will provide plenty of opportunity for preparation. Thank you, Judge. The court, very well. Is there anything else either party wishes to bring up on the record at this time? Attorney Kratz, could we just have a moment, Judge? The court, Yes. Attorney Kratz, we understand, Judge, that some scheduling or logistic matters will be addressed by the court later today in a meeting, and that there was some other scheduling or other agreements that were placed or discussed in chambers, but nothing that I believe needs to be placed on the record at this time. The court. Thank you. Mr. Strang? Attorney Strang, the only other matter I would like to have your honor, is just a reiteration of our concerns and a request that any proceeding, or telephonic or otherwise, in which the court and the parties go beyond discussion strictly limited to scheduling, we'd like arrangements to be made for the participation in person or by telephone of Mr. Avery. I realize that the schedule is fluid and that court may have to convene other hearings. Purely scheduling matters, of course, need not involve Mr. Avery, but to the extent we get into anything other than scheduling, we simply reiterate the request that he be included, present in some practical fashion. The court. All right. Well, certainly there is a statute, aside from the fundamental fairness, that requires that take place. And if there is anything else we have to go on the record for that doesn't involve scheduling, that's what we'll do. Today's hearing was only scheduled to be a status conference, but the parties notified the court ahead of time that there were some items that need to be dealt with on the record, and that's how we wound up here today. If necessary, we'll do it again in the future. Attorney Strang, thank you. The court, anything else today? Attorney Kratz, not on the record, Judge. The court, very well. If not, we're adjourned for the day. Attorney Buting. Thank you, Judge. The court, let's go back on the record. Mr. Buting, you had a clarification question? Attorney Buting, did the court rule then that the motion we filed is going to be unsealed or is unsealed? The court, I intend to issue that order to unseal the motion. Attorney Buting, okay. The court, with respect to the evidence that's the subject matter of the motion itself, I indicated that I would withhold ruling on that at this time pending what I will anticipate be an agreement between the parties. And if the parties do not come to an agreement and the state asks for the motion to have evidence unsealed, I will rule on the motion when it comes in. Attorney Buting, so in the meantime, the evidence that's subject of the motion will remain sealed. The court, yes. Attorney Buting, thank you. I just wanted to clarify that. The court, very well. We're adjourned for today. Proceedings concluded.